Colbert? Colbert? Okay. Appearances?
Good morning, Your Honor. Jody Carbone, Assistant Prosecutor on behalf of the state.
Your Honor, good morning. Edward Cridge of Milk O'Neill on behalf of Mr. Colbert.
All right. Does he have a copy of his plea form?
Yes, Judge. I reviewed it with him on Friday last week and gave him a copy. He doesn't have it with him.
Just give him a copy now,
May I stand with him, Judge?
if you want.
Thank you.
But first he needs to be arraigned, and this is on an accusation? Okay. So, the first thing I want to talk to you about, first off, Mr. Colbert, wait a minute. This is, okay. Well, I don't have to arraign him on an accusation. Mr. Colbert, I have here a plea form that corresponds to accusation 19-6-527. Charges you with aggravated sexual assault in the first degree and essentially lesser included offenses from there. Did I swear you in? Do you swear or affirm to tell the truth? Okay. So, this accusation has a corresponding waiver of indictment. And you signed that waiver. Do you know what you're waiving?
Yes, sir.
What are you waiving?
Right to trial?
No. That's a plea form. You're waiving your right to have this matter presented to a Middlesex County grand jury, which is an independent body of 23 people. It's an arm of the court. You have a right to have them review your case to determine whether or not you should even be charged. Because the grand jury doesn't necessarily indict everybody. You're waiving that right, and you're going forward with the prosecutor's accusation. So then the question becomes, well, why would you do that? Why would you give up that constitutional right? And I suspect, and you could tell me if I'm right or wrong, I suspect it has to do with the fact that you have a favorable deal, or what you consider to be a favorable deal now, that you would like to avail yourself of, and you're nowhere near getting indicted, scheduling-wise, and but you want to take advantage of that deal now, and at the end of the day, you really don't doubt that you probably get indicted anyway. So, are those statements true? Is that why you're waiving your right?
Yes, sir.
Yes? Okay. All right, so I find he's making this waiver free, voluntarily, knowingly, and intelligently. Mr. Chris, you agree?
Yes, I do, Your Honor.
All right, I signed the waiver. I mean, if you want to, I never arraigned anybody on an accusation before, but, well, he's going to plead, but you're waiving a formal reading, you enter a plea of not guilty, subject to this retracts it, and you've got discovery and a plea offer?
Yes, Your Honor.
All right. I don't think we ever did an arraignment order on an accident.
It's so funny, just every other courtroom does that, and that's why I asked that it be done, and I always thought it was for stat purposes. Now I know in this courtroom you don't.
It just never came up. Makes sense, but, and I gotta make sure you got discovery and a plea offer. Okay, all right, so, the first question I have for you, Mr. Colbert, you're pleading guilty to first-degree aggravated sexual assault. In order to plead guilty, you have to be guilty. Are you in fact guilty of this charge?
Yes.
All right. As I mentioned, you don't have to waive that right to go to a grand jury. You can take this, see if you get indicted. If and when you get indicted, you have a right to take that indictment to trial. We would fill the jury box. The state would have to prove to 12 jurors beyond a reasonable doubt that you were guilty. If they couldn't do it, you couldn't be convicted. Do you understand that? Okay. But you're pleading guilty, which means that you're waiving, there won't be a trial. So you're waiving your right to a jury trial? obviously, right? You have an absolute right to remain silent. In other words, you don't have to speak against yourself. But implicit in a guilty plea is an admission. You got to tell me what it is you did that makes you guilty. So in that sense, you're waiving your right to remain silent? Okay. You also have a right to confront witnesses against you, which means being physically present when they testify against you, to cross-examine them with your lawyer's assistance. But after today, there's not going to be any witnesses. So you're waiving that right as well? Yes, okay. On the first page here, you'll see where it says life. That's actually erroneous. There are certain species of aggravated sexual assault which that could be the maximum term, but yours isn't one of them. You face, if you took this case to trial, he has no record?
Correct, Judge.
Okay.
Maybe a very minor disorderly person's offense.
Oh, all right. Well, it doesn't matter. All right. Here's the way it works, Mr. Colbert. On a first-degree charge and a second-degree charge, regardless of whether you have a record, if a jury finds you guilty with no deal, no plea agreement, then under the law, there's a presumption of imprisonment, right? I mean, you will go to state prison because there's a presumption of imprisonment regardless of whether you have a record. On the first degree, it's 10, not life, it's 10 to 20 years. On the second degree, it's 5 to 10 years. Okay? Your record would come into play with the duration of that term, but the presumption of imprisonment sort of suggests that it's pretty much a certainty that you would go to state prison on a first or second degree. In other words, probation would not be an option. Count 3 is also no early release act, and count 5 isn't, right?
Three,
1 and 3 are.
five's not, yes.
So, okay, you got a first degree 2 seconds. Count 1 charging aggravated sexual assault and count 3 charging sexual assault. Those, not only do they have a presumption of imprisonment, but they also come under what's called the No Early Release Act, or commonly known as NERA, N-E-R-A. And that compels that whatever sentence is imposed, you must serve 85% of the sentence without parole. So, for example, let's say you got a 5-year sentence on the second degree. You'd have to serve 4 1/4 without parole, because that's 85%. If you got a 10-year sentence, you'd be serving 8 1/2 without parole. If you got, and you can get a 10-year sentence on the first degree as well. Again, 8 1/2, no parole. The highest on the first degree would be 20. So, by way of example, 85% would be 17 years, no parole. Do you understand? Okay. Count 5, endangering the welfare of a child, second degree. It's the second degree, there's a presumption of imprisonment. However, that does not, so it's 5 to 10, but it doesn't fall under the No Early Release Act. So that would not require an 85% parole disqualifier. Do you understand? Okay. You have a soft voice. The record should reflect that so far he hasn't answered in any way that he's answered yes to everything. He understands. Counts 2 and 4 are third degree and fourth degree respectively. For someone who has no record, the presumption goes the other way. So if a jury came back not guilty on the first degrees or the second degrees, then, and found you guilty of a third or a fourth, if you had no record, I could tell you you're pretty much guaranteed not going to state prison because there's a presumption against imprisonment for first-time offenders for third or fourth degree charges. What happens if somebody has a record, even a minor record, which apparently you do? Well, you don't get that presumption against imprisonment. So if you got convicted by a jury of only a third or fourth degree, what would happen to you with sentencing? It's wide open. On the low end, you get straight probation, no jail from 1 to 5 years. You could, on the high end, on a third degree, you could get 3 to 5 years in state prison. On a fourth degree, you can get up to 18 months in state prison. Or you could get a hybrid sentence, which is probation with a special condition of up to 364 days in the county jail. All right? What I just went over with you is what your exposure would be on this indictment, on these charges. This is an accusation. Without, I take it the indictment would mirror this accusation.
Actually, Judge, one of the reasons that there was this resolution was there are uncharged second-degree official misconduct charges, which would have been 525. So that wasn't charged. It would have been had we gone to the grand jury.
Oh, well, all right. That's important that I know that. So his exposure, so if it did go to the grand jury, that's additional exposure. 5 with a 5, up to 10 with a 5?
Correct, Your Honor.
I mean a hard 5.
A hard 5 that would have been consec.
Well, could be consecutive. I mean, do you know the difference between consecutive and concurrent? What I'm trying to go through with you now is to make sure you understand if you didn't have the plea agreement, what could happen to you. So what she's telling me is if it was taken to grand jury, in addition to these charges, there would be second-degree official misconduct charges, which would carry it's 5 to 10 years, presumption of imprisonment, carries a 5-year parole disqualifier. And then you got to worry about whether it would run concurrent or consecutive to these underlying sexual assault charges. Concurrent would be good for you because they run at the same time. Consecutive wouldn't be good for you because they'd be stacked on top of each other. And we're looking at a lot of parole disqualifiers with these counts. So those parole disqualifiers could essentially be stacked on top of each other. Do you understand? Okay. The other thing to point out to you is, if they found you guilty of second-degree official misconduct, state prison is pretty much a virtual certainty. And you can't be in state prison and on probation at the same time. So these third and fourth degree charges, where I told you where probation could be in the cards, they would not be in the cards if, in fact, you got convicted of official misconduct, because you would be going to state prison. So you would have to get a prison term on those as well, and then deal with the same issues as to whether they were concurrent or consecutive. Do you understand? All right. So that is your exposure on this whole matter without a plea agreement. But you made a deal, and the deal you made, that is in exchange for your guilty plea to the first count of this accusation charging first-degree aggravated sexual assault. So just to be clear, where it says life here on the first page, that's erroneous. It should say 20 years. Okay? It's 10 to 20. It's not life. Do you understand? Show them the paper. Do you understand? There are some aggravated sexual assault cases where life, it has to do with timing, but yours isn't one of them. Okay, do you understand? Okay. All right. I know you have a record, I think it's for a disorderly persons offense, but...
I believe it was a DWI from out of state where it may be considered a criminal offense.
All right, well, the important thing for you to understand now is, well, then your lawyer, if it was the equivalent of a Title 39 offense here, then you may be entitled to the presumption of against incarceration for a third or fourth degree. So, my point being is just that you understand the law, and to apply it to what your exposure would be. Do you understand? You sure? Okay. At this point, you will have an indictable criminal record. Do you understand that? Okay. There's some mandatory minimum penalties that I must impose. There's a $100 VCCB, $75 Safe Neighborhoods fee, $30 Law Enforcement Officers Training and Equipment Act fee, and you must give a DNA sample. Are you agreeable to those things? Okay. There's certain other fines that have to go with you that have to deal with this particular charge, and I'll talk to you about those. The deal you made is you're going to plead to the first degree, and they are going to drop you down to the second degree range for sentencing. And actually all the way down to the bottom of the second degree range, which is 5 years. But it'll be subject to the No Early Release Act. It'll be subject to Megan's Law, parole supervision for life. What do you do, work-wise? You have a public job?
Yes, sir.
What is that?
I was working at the Brunswick.
Oh, all right. You're going to forfeit public employment. Do you understand that? Okay. You can't have any contact with the victim. Your lawyer is going to ask that you be ROR'd till sentencing. The state's going to object. So, that's up in the air. You still want to go forward? No. He's going to argue to get you out. She's going to object. That's up in the air. I don't know what's going to happen. Do you still want to go forward? Okay. So it doesn't get any lower. In other words, quite frankly, without the state being on board, it would be virtually impossible under the law to drop you down a degree for sentencing. Unless they're on board and they're agreed to it as per a plea agreement. But it won't go any lower than that because you're getting dropped down a degree and you're getting the lowest sentence for the second degree range. Do you understand that? So it would be 5 years. It would be subject to the No Early Release Act, and they have 5 years, 3 months. Right. I'm sorry, 4 years, 3 months, which is 4.25 years, which is 85% of 5. Do you understand? So you'll have to do every day of 4 years, 3 months before being eligible for parole. Do you understand that? You're a citizen, yes? Is there restitution in the case, prosecutor?
Judge, I don't believe so, but I would just ask that after, the victim's family is questioned about that I can get back to you if there is restitution, if they ask that it be included.
Number 15 is circled yes. It says that you're willing to pay restitution. Do you know what restitution is?
But I paid to the family.
Well, it's for unreimbursed expenses. So say, for example, hypothetically, this victim went to counseling or something like that, and there was co-pays or deductibles. Theoretically, you'd be on the hook for that. Are you agreeable to that? Number 16, it talks about being a public employee, and you're forfeiting your office or your job. And that's part of the deal, and you're agreeable to that? Okay. Aside from the potential official misconduct, is it fair to say that count 1 is the lead count and the rest of the indictment are lesser included?
Yes, Your Honor.
All right. So, in other words, if you took the case to trial and you got convicted, for all intents and purposes, that would be the one charge that you'd be sentenced on. The rest of them would probably merge into the... and did your lawyer discuss with you the doctrine of merger?
Yes.
Well, it's circled yes on question number 19. Okay. Paragraph 21, there's nothing written. Any other terms, promises, representations that have been made to you that I don't know about? This is everything, right? Anybody force you or threaten you to take this deal? You're doing it of your own free will? And are you satisfied with your lawyer's advice? Do you have any questions? You sure? Okay. The record should reflect you just shook your head yes, and then you said, I'm sure. Try to keep your voice up. Now, these types of offenses, there's some other forms I have to go over with you. The first one has to do with the Adult Diagnostic and Treatment Center. So you're going to get a sentence date that's going to be far enough out so to accommodate an evaluation. You will be transferred to the Adult Diagnostic and Treatment Center. Do you know what that is?
Avenel?
Yes. It's also known as Avenel. And it's right across the street from Railway State Prison. The thing about the Adult Diagnostic and Treatment Center is that everybody in there is a sex offender. But the people in there have been evaluated and have been deemed to fall under the statute as being repetitive and compulsive. If you meet that criteria, you will be eligible for sentencing at the Adult Diagnostic and Treatment Center. Do you understand that? The reality of the situation is, but you're getting an 85% parole score, but nonetheless, generally speaking, if you take two guys, both with the same amount of credit, both with the same term sentence, and you put one in Avenel and the other in Railway State Prison on the same day, the guy in Railway is coming out a lot sooner than the guy in Avenel. The reason is because, generally speaking, with regular state prison, the regular parole guidelines apply for purposes of release. But with Avenel, your parole is governed by a special classification and review board. And they won't parole you until they feel you can make an acceptable adjustment into the community. So the reality is, the people going to Avenel do a lot more time. Many of them max out on their terms. You understand? Still want to go forward? If you're unhappy, let's say they find that you're repetitive and compulsive, and you don't think you are, and you don't want to go to Avenel, you can challenge that finding. And we'll give you a hearing in that regard, where you'll have an opportunity to challenge that finding from the Avenel evaluator. Do you understand that? All right. There's a couple other things, too, about Avenel. What happens if you're deemed to be repetitive and compulsive and you're eligible for Avenel, but you're not willing to go, you're not willing to participate? Again, it's a no early release act, so it probably doesn't really matter much, but you're not going to get out any earlier by refusing to participate and going into the normal state prison sentence. In other words, you'll get as much time as if you were in the Adult Diagnostic and Treatment Center. Also, if you're not repetitive, if your conduct is not characterized as repetitive and compulsive, or you're not amenable to treatment, then You will not become primarily eligible for parole until you've served any mandatory minimum term imposed by the court. So that's the 85% to 4.25 years. Do you understand that? There's okay. And under this situation, there would be a 1/3 parole disqualifier, but that would be subsumed, or, that would be, wouldn't matter because you had the 85% parole disqualifier. But also, you need to know that that period that you serve without parole, with the parole disqualifier, will not be reduced by commutation time for good behavior or work credits. Do you understand? Okay. Okay, Megan's Law. You're going to be subject to Megan's Law. And Megan's Law is essentially two things. There's a registration component, and there is a notification part of it. So once you get released, I think you have 10 days, wherever town you're going to live in, you got to register with the local police, right? So that they're aware of your conviction, where you're going to be living. Before you get released, you will be tiered, either 1, 2, or 3. There's 3 levels, to determine your risk of reoffense. If you're in the lowest tier, when you go to register, it's just the police that are notified. If you're in the middle tier, it's the police and perhaps community groups where children are likely, like Girl Scouts and things like that, would be notified. If you're in the highest tier of risk of reoffense, you should assume everybody is going to find out. Same deal. If you don't like the tier that you fall into, just like the Avenel finding, you can ask for a hearing to challenge that. All right? And then, if you were repetitive and compulsive, I think you got to re-register. How often? Every 6 months?
I believe the address registration, Judge, is up to every 90 days.
Right. If you're repetitive and compulsive, it's every 90 days. If you're not, it's once a year. Okay? Do you understand? Failure to register or re-register is a third-degree crime. It's a separate third-degree crime, which can end up in state prison for up to 5 years. Do you understand that? Now, here's the thing about that. You're also going to be on parole supervision for life. You can't be on probation and parole at the same time. So, if you violate this while you're on parole supervision for life, you can forget about probation. These are third-degree offenses. It would be 3 to 5 years in state prison for each violation. Do you understand?
Yes, sir.
Okay. So this parole supervision for life, you're going to be on parole, supervised potentially for the rest of your life. You can petition to get off of it after 15 years, but that's up in the air and there's no guarantee. Do you understand that? There's a lot of restrictions that may come with parole supervision for life. Where you can live, whether you can have contact with children. So a violation of parole supervision for life is only a 4th degree? Or is it a 3rd now? third? PSL violation? Isn't that what Hester was all about?
Yes, it's now a third degree.
Third degree. So on page 4 of 5, with a violation of parole supervision for life, your parole can be revoked and sent to state prison for 12 to 18 months. I think it's actually 3 to 5 years. Do you understand?
Yes, sir.
Okay. All right. You may end up on an internet posting, as I indicated to you, with all your identifiers. In other words, the whole world can find out about your situation. Do you understand that? And also, is he limited on computer use?
It's in the form, Judge. He has to report his computer use to law enforcement. I guess
Right.
register the computer, et cetera.
In other words, you lose privacy on the computer. You're agreeable to that?
Yes.
They're mainly concerned about internet. Do you understand?
Yes.
Okay. So there's fines, additional fines. There's a sexual assault nurse examiner fee, that's $800. It's mandatory. There's also a $2,000 sex crime victim treatment fund penalty, and I believe sex offender supervision fund penalty. Is that only if you're on probation, $30 a month? But, which I think it is. However, there is a surcharge of $100, which I believe has to do with domestic violence. Surcharge on number 8 on page 5 of 5. So you're looking at 2,900 additional penalties. Do you understand that? Okay. Now here's another thing. This thing about civil commitment. There are some people in Avenel, they won't let out. Even though they're done with their sentence, they've maxed out, they're done with the criminal justice system, but they're deemed to be too dangerous to let out, and they end up getting civilly committed. Potentially, you could fall into that, wherein they, you finish your criminal term, your sentence, you're all done, you're off parole, you're done, you maxed out, but yet they still won't let you out. That potentially could happen to you. Do you still want to go forward?
Yes.
This is an Early Release Act form. It's a first degree. All right, so we know, right, you're going to get 5 years, 4 1/4, no parole. So let's say you get out at 4 1/4. It's a first degree crime. So you will be on parole supervision for 5 years. This is not part of the parole supervision for life. This is a special parole for the No Early Release Act. So what happens, you're out for, say, 18 months. You violate that parole. You still have 3.5 years to go on your parole. They can incarcerate you for the remaining 3.5 years, even though that'll put you past the 5-year sentence. Do you understand? All right. I think I hit everything with you. I swore you in, right? You want to take the factual basis, counsel?
Thank you, Your Honor. Mr. Colbert, good morning. Is it true that during the time period between November of 2018 and March 2019, you were working as a paraprofessional at the New Brunswick Middle School?
Yes.
Okay. And as part of your job as a paraprofessional, were you supposed to supervise students at the school where you worked?
Yes.
And between November 2018 and March 2019, was there a female student at that middle school whose initials were and at some point between November 2018 and March 2019, at the New Brunswick Middle School, did you place the tip of your penis inside White's vagina?
Yes.
I'll submit, Your Honor.
And you don't dispute that her birth date was 2005, correct?
Is that correct?
Yes.
State satisfied.
When they say you were a paraprofessional, what did you do for the school?
I worked with special education, 7th grade, self-contained.
In the classroom?
Yes.
Essentially as a teacher.
Well,
You were a paraprofessional, but
teacher help.
teacher's helper. And this child was a student there, right? And given your position, is it fair to say that you had supervisory or disciplinary power over that child? Well, you were in the classroom with the teachers. In other words, you supervised this child during the school hours, correct? Fair enough?
Fair, yes.
State satisfied.
All right, I'm satisfied Mr. Colbert provided a factual basis for first-degree aggravated sexual assault. He is, in fact, guilty of that offense. I'm satisfied he's entering into this plea agreement freely, voluntarily, knowingly, intelligently. In that regard, waiving his rights. Mr. Colbert, let me ask you something. This is a one-time deal or it happened more than once?
Yes, back at one.
Since it's got to go to Avenel.
September 6th.
Okay, your sentence date will be September the 6th. That should be long enough for you to go to Avenel. I'll have to sign an order to transfer you to Avenel for your evaluation. All I can tell you is, look, be honest with that Avenel evaluator, all right? So September 6th at 9 o'clock, that'll be your sentence date.
Judge, at this time, I would like to make the application for Mr. Colbert's release pending sentencing. I would just note for the court that Mr. Colbert was aware that he was under investigation for some period of time before he was arrested and charged. When we appeared at his pre-trial detention hearing, Judge Rivas did not find that he was a flight risk. One of the concerns that Judge Rivas had at that time was the possibility of Mr. Colbert interfering with the case based on an allegation that he had deleted some Facebook messages. Clearly, that's no longer an issue in this matter. Mr. Colbert advises me that he would like to be released so he can get some affairs in order, including addressing some outstanding student loans that he has. He is a college graduate and would like to just dispose of those financial matters prior to his beginning his prison sentence. Your Honor, Mr. Colbert also has prior to his incarceration, cared for his mother, lived with his mother, and would like to have the opportunity to do what he can to sort of get her affairs in order as well. And she was present earlier, Judge. She has stepped out of the courtroom for this part of the proceeding.
Obviously, Your Honor, the state objects. First of all, he no longer enjoys the presumption of innocence. There was a lengthy detention hearing where Judge Rivas did detain the appellate division to confirm that detention, and I don't believe there's been any real change in circumstances with regards to any of that issue. I do understand that now he has pled guilty, and there may be less of a chance of witness tampering, but the family was ostracized. And the state still has concerns about that happening prior to sentencing.
Wait, Judge Rivas detained him.
Correct, Your Honor.
Judge Rivas detained
Yes,
him.
Judge.
And that was appealed to the appellate division. The appellate division affirmed that detention.
The biggest thing, Mr. Colbert, is the fact that you're no longer cloaked in the presumption of innocence, and there's a presumption of state prison that goes along with this. Given those, obviously, the risk of flight is apparent under those circumstances. So the application for ROR is denied. Tell me about these Facebook postings.
There was my Facebook postings weren't even about her. My Facebook postings was just posted on Facebook that I was told to deactivate my Facebook by New Brunswick Board of Education because I was under investigation with them. And they actually told me to get rid of all social media while I was still under investigation.
Did you ever communicate with this child via social media?
I communicated with all my players and managers through social media.
Did you ever communicate with this particular child via social media?
Yes.
Make sure you bring that to the evaluator's attention. All right, because I'm going to remember that, and I'm going to get their report, and I'm going to be looking for that. September 6th.